Welcome to the Maine Real Estate Roundtable podcast. I'm Bobby Grenier, your trusted guide to navigating the world of real estate in Maine. Get ready to debunk mortgage myths, unravel real estate mysteries, and learn tips to avoid costly mistakes. Whether you're an industry pro, an overwhelmed buyer, confused seller, or simply curious about life in Maine, this is the podcast for you. Hey there, welcome to the Maine Real Estate Roundtable podcast. This is a podcast where we talk about all things Maine real estate and beyond. I'm your host, Bobby Grenier, and I'm a real estate paralegal with over 21 years experience working for a closing and title company. Today, we're going to talk about a topic that is not super sexy. How's that for a sales pitch? But I really think it's something important to discuss. So we're going to dive into an essential, often misunderstood aspect of a real estate transaction, and that is the power of attorney. My goal with this episode is for you to walk away with a basic understanding of when a power of attorney, or POA, is needed, how to execute it correctly, and how it is handled by title companies and lenders in a real estate transaction. So let's get back to the basics and start at the beginning. What exactly is a power of attorney? It's a legal document that gives one person, the agent or attorney in fact, the authority to act on behalf of another person, the principal. The scope of this authority can vary depending on the type of power of attorney, and it can be broad or limited to specific tasks. The parties for the power of attorney are the principal, and the principal is the person who grants the authority to the agent. The principal must be mentally competent at the time the power of attorney is created and signed, and can specify what decisions the agent is allowed to make. The agent, or attorney in fact, is a person who is given the authority to act on behalf of the principal. The agent's duties might include making financial decisions, handling legal matters, or managing healthcare choices, depending on the POA's scope. In our case, it's to sign real estate documents. A power of attorney is used for a lot of different reasons in a real estate transaction. Maybe the buyers or sellers are unable to attend the closing due to age-related factors, illness, mobility issues, or disability, and the POA allows another trusted individual to act on their behalf. Oftentimes, it's travel conflicts. The buyer or seller isn't in town or unable to attend the closing for that reason. And then there's always military deployments, so service members who are deployed or stationed far away can use a power of attorney to ensure their interests in the transaction are protected while they are away and serving our country. I think it's important to understand the types of power of attorney. So there is a general power of attorney, and this grants broad authority, allowing the agent to handle a variety of matters, including financial, business, and real estate transactions. However, it may not be appropriate for specific transactions because it can raise questions about the scope of the authority granted by that power of attorney. We prefer to use a limited or transaction-specific power of attorney, and that's tailored to one particular transaction. This POA specifies what the agent is authorized to do. For example, sign closing documents, maybe deposit the proceeds check into the bank account, but it provides clarity and assurance to lenders and title companies. The benefits of using a power of attorney, there are so many, but basically ensures that the transaction can proceed smoothly even in the absence of the principal, and that would generally be the buyer or the seller. A few tips for having your power of attorney prepared. The first one being, don't just pull a power of attorney offline. Please have an attorney in the state that you're working in or you're going to do your transaction in prepare the power of attorney. And take the next step to have that power of attorney approved by your lender or title company. This is a very important step because so many times people will present an executed, notarized power of attorney and it cannot be used for your real estate transaction because it does not have all of the proper language that we need. The power of attorney always has to be notarized, so the principal or person granting the power of attorney must sign the document in the presence of a notary public. The power of attorney needs to have clear and specific language that defines the authority granted to the agent, such as the ability to sign those real estate documents and conduct all the necessary actions to complete the sale or purchase of real estate. There are some common pitfalls. The big one is using outdated forms or templates that do not comply with the current laws and can lead to invalidation or simply cannot be used. So again, please make sure the power of attorney that you plan to use for your transaction is approved by your lender and your closing company. Title companies and lenders will thoroughly review the power of attorney document for validity, ensuring that it meets state-specific legal requirements, and this includes checking that the POA is properly executed, signed, notarized, witnessed, and confirms the agent's authorities. Lenders may require additional documentation to accompany the POA, such as a copy of the principal's identification or proof of their relationship to the agent. A power of attorney used in a real estate transaction has to have two important notices, and that's the notice to the principal. That informs the principal about the authority being granted and emphasizes the importance of choosing a trustworthy agent, and then the notice to the agent, and that clarifies the agent's responsibilities, ensuring they understand their obligations to act in the principal's best interest. This wording is very specific, so again, I'm going to say it many times. Make sure that power of attorney is approved by your title company and your lender. Another misconception that we run into is that a trustee, a member of an LLC or a corporation, or the personal representative of an estate thinks that they can grant power of attorney to another individual in a real estate transaction. A trustee, a personal representative, a member of an LLC are all individuals who have specific fiduciary duties and cannot delegate those responsibilities through a POA. So discuss with your attorney or your closing company some alternative methods for delegation of the powers to get those documents signed. In most cases, we need to get that power of attorney recorded at the Registry of Deeds. And in this case, we will request the original signed power of attorney so we can get that put on record. A lot of times, especially if it's a general power of attorney, there's a lot of angst in providing that original, and we totally understand, but we do our recording electronically, so we're usually able to record that document electronically while the agent is in our lobby, and we'll pass them their original right back, but we will be requesting that original be provided so we can get that on record at the Registry of Deeds. Because if an agent signs a document that needs to be recorded, a deed, a mortgage, any of those documents, then the power of attorney also has to be put on record. By recording the original power of attorney, the closing company helps prevent future legal challenges regarding the validity of the transaction. It ensures transparency and establishes a document chain of authority that can be referred to if questions arise later about the agent's power to act in the real estate transaction. And I want to emphasize again, if you are using a lender and you intend to use a power of attorney for your purchase, the lender must approve using that power of attorney. It is so important that you tell them right out of the gate or as soon as you know that you would like to assign a power of attorney to sign your documents on your behalf so that the lender can approve the use of the power of attorney and approve the power of attorney itself. So to sum it all up, a power of attorney is crucial for individuals who cannot be present for a real estate closing due to health issues, travel, or other circumstances. There is the general power of attorney, which gives broad authority, and a transaction-specific power of attorney, and that's limited to one transaction, including the need for clear documentation and notarization for both types of powers of attorney. Correctly executing the POA involves drafting a clear document that's approved in the state that you're doing your transaction, ensuring notarization, and following state-specific requirements. Title companies and lenders require thorough verification of the POA to confirm its validity and that it meets their guidelines, which may include lender-specific approvals. There are some restrictions on certain individuals. Trustees, LLC members, personal representatives cannot grant a power of attorney for real estate transactions due to fiduciary duties and legal obligations. And we absolutely have to record that power of attorney at the Registry of Deeds if the document that the agent signed does need to be recorded again, such as a deed or a mortgage. And always, always get that lender approval if you're a buyer that plans to use a power of attorney. Well, I hope this was helpful. I want to remind you again that I am not an attorney. You should always discuss powers of attorney and any other legal matters with an attorney for your specific situation. But this gives you some basic knowledge on what a power of attorney is, when it can and cannot be used in a real estate transaction. If you want more information, head over to mainrealestateroundtable.com and click on the show notes page for more information or a summary of everything I talked about here today. Thank you so much for listening. Until next time, keep it real. This has been the Maine Real Estate Roundtable podcast with Bobby Grenier. I hope you enjoyed today's discussion and will share this episode with a friend. And don't forget to leave a review and follow the podcast so you don't miss new episodes. The content of this podcast is for informational purposes and not intended as legal advice or representation by myself or any of the guests on the podcast. Thanks for listening, and until next time, keep it real.